So Dilyana, the floor is yours, please.
Thank you. Hello, dear colleagues. While I share my screen, I would first like to say what a great pleasure and privilege it is to be here today and to be able to participate in the discussion on the rights of people with intellectual and psychosocial disabilities in criminal proceedings. I would like to thank the team of the Center for the Study of the Democracy and especially Mr. Dimitar Markov for giving me the opportunity and trusting me with the responsibility to work on the ObsidianNet project. I hope you can see my presentation now. Is everything okay? Okay. Now, several studies have demonstrated that psychological vulnerabilities in police suspects could interfere with the demand characteristic of an interrogation. Hence, it is no surprise that people with intellectual and/or psychosocial disabilities comprise a disproportionate number of the people who are arrested, who come before the courts, and who are deprived from liberty. Today, I will present one of the papers the ObsidianNet project produced, Vulnerable Offenders, the Rights of Suspects Accused and Accused with Psychosocial and Intellectual Disabilities. The report strived, and I think it succeeded to bring together strands of scientific research from various fields in order to shed some light on people with intellectual and psychosocial disabilities and the challenges they face in their interaction with the police and judicial authorities during criminal proceedings. It also explored the different legal systems in each of the 4 partner countries that were Belgium, Bulgaria, Greece, and Italy, with a focus on how people with psychosocial and intellectual disabilities are treated during criminal proceedings. My presentation today will focus on the notion of intellectual and psychosocial disabilities. Then I will give further context by presenting an overview of relevant human rights standards at international and EU level. And finally, I will give some details about Bulgarian state of play at the time of the preparation of the report. Now, what is an intellectual disability? According to the American Association on Intellectual and Developmental Disabilities, intellectual disability is characterized by significant limitation on both intellectual functioning and in adaptive behavior, which covers many everyday social and practical skills and has age of onset before 18 years old. Deficits in intellectual functioning generally include challenges in reasoning, problem solving, planning, abstract thinking, judgment, and learning from experience, while adaptive functioning deficits results in failure to achieve age-appropriate standards of behavior. Intellectual disability also means a significantly reduced ability to understand new or complex information and to learn and apply new skills. As you can see on the chart, intellectual disability is further categorized into 4 levels of severity: mild, moderate, severe, and profound. Because the great majority of intellectually challenged people suffer from a disability with mild or moderate severity, their deficits may be difficult to perceive in an initial interaction, especially by non-specialists such as law enforcers, judges, prosecutors, and defense lawyers. Hence, it will be relatively easy to overestimate their intellectual capacity to understand the meaning and significance of the complex concepts of judicial proceedings. As a result, people in the justice system often misinterpret the communication and behavioral issues resulting from an individual's intellectual disability. In the area of criminal justice, limited intellectual abilities can influence the ability of suspects and accused to understand questions, articulate their answers, and appreciate their implications. Many people with intellectual disability may respond to questions in a manner they believe is expected of them in order to please a person perceived to be an authority figure. and thus giving answers that he or she believes are the desired ones rather than the correct ones. Moreover, such persons may try to hide their disability and, for example, answer a question to which they do not know the answer so as not to appear stupid. Many individuals with intellectual disabilities also have memory lapses, especially with regards to facts or events they did not identify as important, and these lapses may be easily mistaken for lying. Studies show that people with significant intellectual impairment do not fully appreciate the legal consequences for suspects of making self-incriminating admissions during questioning. Therefore, their ability to make informed decisions during interrogations is impaired, and they are likely to fail to fully appreciate the consequences of their participation in this type of judicial proceedings and believe that if they're innocent, then the system will protect them regardless of their own statements. Now, unlike intellectual disability, which is a medical condition, psychosocial disability is an internationally recognized term used to describe the experience of people with impairments and participation restrictions related to mental health conditions. Due to the individual nature of mental health conditions, no one set of impairments will necessarily characterize the experience of someone with a particular mental health condition. These impairments can include a loss of ability to function, think clearly, experience physical health, and manage the social and emotional aspects of their lives. Although psychosocial disability can be episodic, invisible, and often not well identified, its implications are not to be underestimated. Sorry. Now, certain impairments can interfere with the ability to be flexible, the ability to monitor one's own behavior, and can cause people to become confused. Many people who have mental health conditions are easily distracted by environmental stimuli and find it difficult to focus or concentrate. Someone may not be able to make eye contact or speak to people. People with history of mental health conditions report that symptoms are often exacerbated by stress. Another typical example of psychosocial disability relates to a deficit of the working memory. All of these factors contribute for a particular vulnerability of people with psychosocial disabilities during criminal proceedings, and especially during interrogation. And while not everyone with mental illness will experience psychosocial disability, certain conditions such as schizoid disorders, anxiety disorders, and mood disorders involve significant long-term psychosocial impact. Psychosocial disability can intensify the negative effects of mental health conditions by causing social isolation and economic marginalization that can spiral into crisis, homelessness, poverty, and risk of harm. Not unlike people with intellectual disability, people with psychosocial difficulties often try to manage or ignore their impairments in order to appear normal and avoid the stigma experience. Now, during the second part of my presentation, I'm going to talk a little bit about the international standards on rights of people with disabilities. In the actual full report, there's a chronological review of all relevant international documents. Some of them are not legally binding, yet had an important political meaning and influence future policies. Today, because I only have 20 minutes to talk, I will present only the legally binding international and supranational instruments dedicated to people with intellectual and psychosocial disabilities. Now, the European Convention on Human Rights was the first instrument to give effect to some of the rights stated in the Universal Declaration of Human Rights and make them binding. The ECHR does not provide a definition of disability. However, its Article 1 states that the high contract parties shall secure to everyone within their jurisdictions the rights and freedoms defined in this convention. Although not expressly featuring in the list of protected grounds, disability has been included by the European Court of Human Rights in its interpretation of other grounds for discrimination under Article 14. There are a number of cases where the court is considering the rights of people with disabilities and granting them protection. Intellectual and psychosocial disabilities in particular are most commonly detected in the case law of the European Court of Human Rights when it comes to violation of Article 3, that is prohibition of inhuman or degrading treatment, and Article 6, that is the right to a fair trial. Now, the European Court of Human Rights has held on many occasions that detention of a person who is ill may raise issues under Article 3, and that the lack of appropriate medical care may amount to treatment contrary to that provision. In particular, the assessment of whether the conditions of detention are incompatible with the standards of Article 3 has, in the case of mentally ill persons, to take into consideration their vulnerability and their inability in some cases to complain coherently or at all about how they are being affected by any particular treatment. Three elements are to be considered in relation to the compatibility of an applicant's health with his stay in detention. First, the medical condition of the prisoner. Second, the adequacy of the medical assistance and care provided in detention. And third, the advisability of maintaining the detention measure in view of the state of health of the prisoner. Moreover, detaining a person suffering from a mental illness in a normal prison where he is treated as an ordinary prisoner is also considered a violation of Article 3 because the court found that the nature of the applicant's psychological condition made him more vulnerable than the average detainee, and that his detention might have exacerbated his feelings of distress, anguish, and fear. The European Court of Human Rights also observed that prisoners with serious mental disorders and suicidal tendencies required special measures geared to their condition, regardless of the seriousness of the offense of which they had been convicted. According to the court, in cases concerning compulsory confinement, a person of unsound mind should be heard either in person or when necessary through some form of representation. A decision on a person's mental capacity based purely on documentary evidence is deemed unreasonable and in breach of the principle of adversarial proceedings enshrined in Article 6 of the Convention. Now, the next important source, this is the United Nations Convention on the Rights of Persons with Disabilities, which provides specific guarantees regarding access to justice for persons with disabilities, and is probably the most important international treaty with a specific focus on rights of people with disabilities. The convention does not provide a close definition of disability, and that is a conscious choice. Its preamble states that disability is an evolving concept. Nevertheless, the convention does reflect a social model of disability, as it clarifies that disability results from the interaction between persons with impairments and external barriers, both attitudinal and environmental, that hinders their participation in society. Thanks to its fluidity, the notion of disability can be adapted to the prevailing environment in a particular society. In this context, two concepts are of particular importance. First, this is access to justice, and second, reasonable accommodation. Now, effective access to justice is a precondition to the full enjoyment of all other rights and fundamental freedoms. It encompasses the right to legal standing to bring cases. However, the CRPD acknowledges that people with disabilities may have personal barriers to accessing legal procedures for defending their rights. As already mentioned, people with intellectual and psychosocial disabilities are particularly vulnerable during judicial proceedings. This is why the Convention calls for guarantees they can effectively participate in judicial proceedings, which may require making appropriate accommodations in the course of proceedings. Equality is underlying principle of CRPD, closely linked with the perception that disability is a disadvantage that occurs when persons with impairments meet an inaccessible environment. It is not about creating separate or special rights for persons with disabilities, but about including persons with disabilities in the existing human rights discourse and tailoring existing rights to fit their needs through a legally binding instrument. And here comes the second important concept, reasonable accommodation. CRPD means under reasonable accommodation that action must be taken to ensure that legal proceedings, including criminal proceedings, are accessible also for persons with disabilities. Persons with intellectual or psychosocial disabilities may not initially understand the implication of certain interactions with state institutions. In such cases, the state and its institutions have an obligation to take positive measures to accommodate the individual to ensure that they are put in an equivalent position with others. Such accommodations may include additional explanation of the nature of the procedural acts or simplifying language used in the proceedings. There are examples of reasonable, these are examples of reasonable accommodation which does not require additional finances or resources from the state. And denying reasonable accommodation constitutes discrimination. Now, on EU level, we have the Charter of Fundamental Rights of the European Union. Although it does not specifically mention people with intellectual and psychosocial disabilities, the Charter recognizes and respects the right of persons with disabilities to benefit from measures designed to ensure their independence, social and occupational integration, and participation in the life of the community. The notion of disability is not defined by the Charter itself, nor is it defined in the treaties or in secondary law, but in its case law, in the context of applying the principle of non-discrimination on the grounds of disability in employment, the Court of Justice has held that the definition of disability must be understood as long-term physical, mental, or psychological impairments, which in interaction with various barriers may hinder the full and effective participation of the person concerned in professional life on an equal basis with other workers. According to the Directive on the Right to Information in Criminal Proceedings, when providing suspects or accused persons with information in accordance with it, competent authorities should pay particular attention to persons who cannot understand the content or meaning of the information, for example, because of their mental or physical condition. Member states shall ensure the suspects or accused persons are provided promptly with information concerning at least the following procedural rights: right of access to a lawyer, any entitlement for free legal advice and the conditions for obtaining such advice, the right to be informed of the accusation, the right to interpretation and translation, and the right to remain silent. The information concerning those rights shall be given orally or in writing in simple and accessible language, taking into account any particular needs of vulnerable suspects or vulnerable accused persons. Suspects, or according to the Directive on the Right of Access to a Lawyer in Criminal Proceedings, suspects or accused persons should be able to waive a right granted under this directive, provided that they have been given information about the content of the right concerned and the possible consequences of waiving that right. When providing such information, the specific conditions of the suspects or accused persons concerned should be taken into account, including their age and their mental and physical conditions. And finally, The directive on legal aid for suspects and accused persons in criminal proceedings provides that member states should lay down practical arrangements regarding the provision of legal aid. Such arrangement could determine that legal aid is granted following a request by a suspect, an accused person, or a requested person, given in particular that needs of vulnerable persons, such as requests, should not, however, be a substantive condition for granting legal aids. Member states shall ensure that the particular needs of vulnerable suspects are taken into account in the implementation of this directive. Now for the last part of my presentation, I will talk a little bit about the legal status of persons with psychosocial and intellectual disabilities in Bulgaria and the procedural rules and practices applicable to them as offenders in the context of criminal proceedings. Oh, sorry about that. Yeah, that's the right slide. Now, in Bulgaria, the regulation of the general legal status with persons of such persons is closely related to their legal capacity and is done in parallel with the regulation of legal capacity of children. Thus, the Persons and Family Act postulates that those of 14 to 18 years of age or underage and those over 18 years of age or adults who, due to weakness of mind or mental illness, cannot take care of their dealings, have their legal capacity taken away and are put under full guardianship, legally equating them to persons under 14 years of age or minors. Like for minors, legal action on behalf of those under full guardianship is only taken by their guardians. Adults with such ailments, whose condition is not that grave to be put under full guardianship, are put under partial guardianship and are legally equated to the underage. Now, the Persons and Family Act is adopted in 1949, and its formulations have little to do with international standards regulating the status of person with psychosocial and intellectual disabilities. A number of NGOs and other social and legal professionals have been for a number of years criticizing the outdated legal framework for seemingly protecting persons' rights by taking them away and advocating for the adoption of new legislation to introduce assisted decision-making and related support measures in the Bulgarian legal framework, but so far without success. In Bulgaria, an accused is examined towards his or her ability to stand trial. The Bulgarian Criminal Code differentiates between the intellectual element or the ability to understand the significance of the committed act and its consequences, and the volitional element or the ability to control one's action of mental fitness. The absence of either of those elements leads to exemption from criminal responsibility. When the person has a mental condition that does not make them unfit for trial, but nevertheless affects their actions, then a reduced sentence should be imposed. An expert psychiatric and psychological opinions are always sought when there is doubt about the mental fitness of the defendant to be criminally liable or about their capacity in view of their physical or mental conditions to correctly perceive the facts of significance to the case and give credible evidence about them. Finally, the compulsory treatment measures under the Bulgarian Criminal Code can be imposed on persons who have committed a crime while being mentally unfit to be criminally responsible or having fallen into such condition before pronouncing the sentence or while serving it. Those compulsory treatment measures can be either entrusting the person to their relatives if they commit to their treatment in a psychiatric establishment, or compulsory treatment in an ordinary or specialized psychiatric establishment in the latter case if the person is considered particularly dangerous. Measures are imposed, terminated, or amended by the court depending on the condition of the person and the needs of their treatment. Compulsory treatment may also be imposed in parallel with an imprisonment or other sentence if the mentally fit for criminal responsibility offender suffered from alcohol or drug addiction. For those imprisoned, compulsory measures take place during the serving of the sentence, and the court may prolong them after the person is released from prison. As Bulgarian law has very few specific norms on the situation of offenders with psychosocial or intellectual disabilities, police and judicial professionals have to rely on general ethical norms and their own good practices when working with such people. Individuals with psychosocial and intellectual disabilities are identified from a very early stage of proceedings when police and prosecution gather data on the alleged perpetrator of the crime under investigation, such as character traits, material and family status, level of intellectual development, mental illnesses, possible stays in a specialized psychiatric institution, etc. Much reliance is made on the personal impressions of investigative police, but expert examinations are also ordered to establish whether the person indeed has a mental illness and whether they can give credible evidence. In general, lack of mental fitness to bear criminal responsibility can be established at any stage during the pre-trial proceedings as well as during the trial before the court. In informing defendants, including persons with psychosocial or intellectual disabilities, about their rights, prosecutors rather rely on what is stipulated in the law, although no both lawful and non-discriminatory way is seen to set a different regime for informing such persons. The approach of authorities is nevertheless adapted. Special rules are only available for people who have speaking, visual, or hearing impairments and who are not in command of the Bulgarian language. Those persons are accorded an interpreter or a sign interpreter. According to police, the appointment of sign interpreters is very much relevant to offenders with psychosocial disabilities since they have such additional impairments. In practice, especially in smaller towns, relative or caretakers are given such roles because they are in best position to explain to the offender their rights and assist police in carrying out their duties. The existence of physical or mental disabilities which prevent the person from executing their own defense is one of the grounds for appointment of mandatory defense in the criminal proceedings under the Criminal Procedure Code. The existence of such disabilities, however, is a matter to prove and cannot be equated to the existence of any psychosocial or intellectual disability. Defense is also mandatory if a request is made to court for the defendant's detention in custody or if the defendant is already detained on some grounds. No waiver of that right is valid. And in case of mandatory defense, the relevant authority appoints a defense attorney. Now, while preparing the Bulgarian country report in early 2019, a series of interviews were conducted with police officers and judicial officials. And in the opinion of police, no guidelines or manual were available for working with persons with psychosocial or intellectual disabilities. Officers could rely on general ethical norms from respective codes of conduct of state officials and police officers, on not allowing acts of torture, inhuman or degrading treatment, punishment or conduct, and not allowing discrimination. No guidelines are reported by judicial professionals either, while a judge interviewed pointed that many judges have nevertheless followed their own good practices in dealing with such persons. According to an interviewed prosecutor, prosecutors do take into account the needs of persons with psychosocial and intellectual disabilities by affording them breaks to calm down, giving them refreshments, and interviewing them with more care. They attempt not to use too many professional terms and speak simply and understandably. They constantly monitor the person's condition because such persons are in principle very much afraid of criminal proceedings, which hinders them from expressing their statements and opinions. Now, in conclusion, I'd like to point out that the most effective response to individuals with mental health issues is often an appropriate balance of supervision, accountability,